I've talked a lot about trespassing in other states. I haven't really covered trespassing in California, so I figured I would. And this is a Judo Johnny video. He is way undersubbed. He's a pretty good auditor. He has some issues with. He's a little high desert community watch with his understanding of some of the statutes like 148G, but he's a good auditor. In this case, he was videotaping in some public access areas of this police station. A different police officer wanted him to GTFO. Judo Johnny asked for the supervisor and got this fine fellow right here who's a sergeant. And Sergeant basically said that if you don't have any business with the police department, you need to GTFO. And he's probably relying on this Adderley v. Florida decision. This was where a group of protesters started protesting on jail grounds, and the sheriff trespassed them. The Supreme Court said that's totally legit. It's the jail is not a traditional public forum, and the trespass statute was content neutral, and it's a conduct restriction basically. So the state, no less than a private owner of property, has the power to preserve the property under its control for the use to which it's lawfully dedicated. And police stations are dedicated to allowing people to come in and file complaints and, fill out statements and things like that. So he's thinking, that makes sense, right? If you don't have official business with the police department, you need to GTFO. Well, the problem with relying on something like Adderley, and I'm not saying he did because that would imply that he read cases, and I don't think police typically read cases. I think they read little statute books. And anyway, so there's two problems with it. First thing is that the Supreme Court held that jail was a non-public forum. California, with their constitution, they have a bit of a broader understanding of what is or isn't a public forum. For example, a prison parking lot is a public forum as far as California law is concerned, and it wouldn't be according to federal law. The other big deal is that Adderley was a Florida trespass statute, and Palo Alto cop is going to have a hell of a time trying to arrest somebody under a Florida trespass statute. He would have to rely on California's trespass statute, and that is 602. My dogs are settling in, so if you hear them licking and moving around and snuffling and probably snoring in a bit, that'll be why. Where the hell is 602? California writes way too many laws. Need a lawyer to figure this crap out. Good God. Alright, 602. So you could take my word for it. The first portion of 602 that even looks like it is going to fit is going to be K. Entering any lands, whether unenclosed or enclosed by fence, for the purpose of injuring any property or property rights, or with the intention of interfering with, obstructing, or injuring any lawful business or corporation carried on by the owner of the land, the owner's agent, or the person in lawful possession. And it's plausible, it's probable that a court will find that the police are the owner's agent, or the person in lawful possession, one of the three, or some combination thereof. The problem with this one is that you have to show, they replace injuring with damaging in the jury instructions. So for the jury to find you guilty of this, they would have to find that you were interfering with, obstructing, or damaging. Injuring is typically related to people. Damaging is related to property. It's just a poorly written statute that they corrected in the jury instructions. So the problem is that you'd actually find that there is some sort of damage. And if you look at case law, this is In re Wallace. This is a California Supreme Court case. The petitioners were leafleting at a state fair. They were handing out leaflets by a tomato picker. They ended up getting trespassed, and according to the testimony of everybody involved, people were still able to go up and check out the tomato picker, and so these people weren't interfering with or obstructing, and therefore that statute didn't apply. If you want to see where it did apply, there's In re Ball, and in this case, the petitioners set up a stand in a paid parking lot in front of the tram at Disneyland, and so Disneyland had to actually reroute where people would get off the tram, so people didn't get off at the right stops because there was this table set up in the way, so people had to walk further. That actually interfered with it. I think that just standing in a police station filming is going to be more In re Wallace than it is In re Ball. Now, if you get a bunch of people and you start blocking, filling up the lobby and everybody's just pointing cameras and nobody's doing police business and you're making it difficult for people to come in, like physically difficult for people to come in and fill out their forms or pay their fines or whatever it is they're going to do in a police station, then it might turn into more In re Ball. But a single guy with a camera in a police station, that's In re Wallace, so K won't work. The next one that we're going to look at is M, entering and occupying real property or structures of any kind without the consent of the owner, the owner's agent, or the person in lawful possession. That sounds pretty good, right? Because, again, we're going to assume, arguendo, that the owner, the owner's agent, or the person in lawful possession of a police station would be the police. But then we have to deal with entering and occupying real property or structures of any kind, and it's the occupying that's going to be the sticky wicket. And the sticky wicket is People v. Wilkins. People v. Wilkins points out that in 602.5 they use entering and remaining for trespassing into a home. L covers entering and occupying, and then they go into why that came into be. This portion right here, there are people squatting. It was an attempt to keep people from squatting. So it intended the word occupy to mean non-transient, continuous type of possession. And in this case, there were 4 people who were camping in a corner of a large ranch, and they had their sleeping bags and a fire, and the court said that that's not occupying. They weren't occupying that area. So if you think that standing in a police station is occupying it, but having four sleeping bags out and a fire, then, well, yeah. So occupying doesn't work. So, and it is an and, so it's entering and occupying. So that's not going to do it. The next one we have is going to be, here we go, Q. Refusing or failing to leave a public building, sounds good, right? Of a public agency, sounds great. During those hours of the day or night where the building is regularly closed to the public. Well, that doesn't really work because obviously the police station was open. So that one's not going to work. T is the one I think that gave us the whole crime thing. You have to commit a crime to be trespassed off public property, that little internet myth. Entering upon public property being contiguous land, real property or structures thereon belonging to the same owner, whether or not generally open to the public, after having been informed by a peace officer at the request of the owner, the owner's agent, or the person in lawful possession, and upon being informed by the peace officer that he or she is acting at the request of the owner, the owner's agent, or the person in lawful possession, that the property is not open to the particular person, or refusing or failing to leave the property upon being asked to leave the property in the manner provided in the subsection. Sounds like it works. Problem is, part 2, this subdivision applies only to a person who has been convicted of a crime committed upon the particular private property. So, no, and also you'd have the problem of, is it private property or is it public property? That would be a good question, wouldn't it? I think that's the last one that really applies in this particular section. And so then we're going to go on to 602.1. 602.1b may apply. 602.1b is the one that I think somebody's going to end up actually running foul of sooner or later doing these audits, especially the ones where they get up in people's faces and hostile and, you know, start demanding attention and standing in front of the counter, etc. Just standing in front of the counter, just filming people trying to type. I mean, that's kind of awkward. I can see. I'm just saying. I'm not saying that they're wrong to do it. I'm just saying that I think B is the one that we're gonna see someone run afoul of eventually. That's any person who intentionally interferes with any lawful business carried on by the employees of a public agency owned or open to the public by obstructing or intimidating those attempting to carry on business or those persons there to transact business with the public agency, and who refuses to leave the premises of the public agency after being requested to leave by the office manager or a supervisor of the public agency, or by a peace officer acting at the request of the office manager or supervisor of the public agency. So that's the one that I think is most likely to ruin some poor auditor's day at some point in the future. And I'm not saying that any of these would, like, there's a lot of stupid cops out there, and a lot of stupid cops will go right to 602M. I've seen it in their forums, because yes, I do troll cop forums from time to time, because, you know, I like to know what they're thinking. And yeah, so I've seen a lot of them throw out M, a lot of them, without realizing that occupying means what it means. Yeah, you don't have to be too smart to be a cop. So then 602.55 is the dwelling one. That was one that was referenced where it said enter or remain. Enters or remains. Boom. Yeah, but nothing else really applies in this section. You know, there's airport ones, and there's citrus fruit fair buildings or grounds. Yes, we have a statute in California specifically for citrus fruit fair buildings or grounds. Yeah. The Sacramento BART. Landowner under cultivation. Yeah, I think I've made my point. Han v. City of Los Angeles talks a lot about some of these. They go through different ones. Not a whole lot of them, but they go through some of them. Like O was boom. This one, not open to the general public. They had a cop who tried to use this one to trespass somebody from a mall, a shopping mall. Yeah. Anyway, so the other big thing was 148G. 148G, once again, 148G refers to Part A. Part A is the everyone who willfully resists, delays, or obstructs any public officer, peace officer, etc. And the purpose of G is to say that just filming a police officer isn't obstructing them or delaying them or interfering with them. And you can tell that's the case because if you actually look at the jury instructions, these are the jury instructions for resisting a peace officer. So this is 148A. In 148A, it has this little section that says taking a photograph or making an audio video recording of a peace officer while the officer is in public, or the person is taking a photograph or making a recording is in a place where he or she has a right to be, is not by itself a crime. And that's important. That's something that auditors need to remember. If you're in California, if the cop wants to charge you for obstructing him in his course or interfering with what he's doing, and you're just filming, this 148G will protect you from him trying to charge you with 148A. But that's all it'll do. I would love to say that someone somewhere has read it to be a much more broad statement than it is, but it is everything I've seen as far as jury instructions, as far as its use in cases. Everything I've seen is it's pointing directly at 148A and saying that 148A, you can't violate 148A just by filming. So there's a lot in California. There's a lot of protections on filming anyway. You don't need 148G to film. There's California, the Constitution of California is very broadly interpreted as far as freedom of speech. Even if you look at the 602.1B, there's this section. So this section shall not apply to any of the following persons. Part 2 is any person on the premises who is engaging in activities protected by the California Constitution or the United States Constitution. So if you're in there picketing, like, first of all, they just cut it out. Like, if you're engaged in lawful labor union activities that are permitted to be carried out on the property by state or federal law, then even if you're intentionally interfering with a lawful business, sorry, dude, they can't trespass you for that. But this B part, this D2, any person on the premises who is engaging in activities protected by the California Constitution or the United States Constitution, one could make a very, very, very strong argument that filming is protected by both the California Constitution and the United States Constitution. And so I haven't seen it applied yet, so I can't say that this is definitely the case, but D2 may be the way that poor auditor who's eventually going to get popped under this 602.1B, this D2 portion may be the way they end up getting out of it. So that'll be something to see. Some lawyer's going to get rich off that. I mean, some auditor's going to be let free off that. I keyed. Anyway, I hope you've enjoyed. Check out Judo Johnny. Like, I know I only have 100 subs and I'm sending somebody at, 1.6K subs. But I'm just saying, if you haven't seen him, check him out. He's a good watch. He does a good job. He doesn't edit down very far, but if you've got the time, it's a good watch. So happy auditing. Stay safe. Have fun out there.